in the matter of SA by her litigation friend and official solicitor.
Yes, Mr.
My lady, my lords, if it please the court, my name is O'Brien and I appear on behalf of the appellant, who is the mother of SA, who is the protected person.
Yes. Before we go any further, can we deal with, because I'm conscious we're live streamed.
And anonymity was on my list. As the next
and mine as well, so there
yes.
we are. Are there any objections to an anonymity order? I mean, of course, as we're all aware, ordinarily the Court of Appeal is an open court, and we rarely make anonymity orders other than to protect the identification of a child or vulnerable person. But it seems clear that in this case that should be done. So if everyone could try very hard to think in terms of initials, which we all hate, but if you could, don't panic, because somewhere, if I remember where it is, there is a lag on the live stream, and also there's a way of editing if absolutely necessary. But it's very much easier if we avoid that. Yes. Now, if I just tell you that we've all had an opportunity of reading the papers, for which I thank you, and that includes not just the original skeleton arguments, but all the refined skeleton arguments. And I think we've all dipped into various of the authorities, particularly the key authorities.
I'm grateful. Thank you very much. Shall I continue with the introduction?
Please do.
So that
Your go now.
Because people are not seated exactly as they should be for various reasons. But it's next to me is Miss Williams-Howe, who appears for the father, the second respondent.
Ms. Howe.
Next to my right is Miss Lee, who appears for the local authority, the first respondent, and on my far right is Mr. Haddon, who appears for SA, the vulnerable person, who is represented by her litigation friend, the official solicitor, who instructs Mr. Haddon. We're also joined by various instructing solicitors, and also the second respondent, the father, is present in court back here. So the mother, as my lady will realise, has got family commitments and is unable to join us today. And we did talk earlier about possible ways of identifying people, and father, mother, and everyone in relation to P would probably be a straightforward way of reminding everyone.
Sounds sensible, thank you.
Who they are. The assumption is that the court will want to reserve judgment, and therefore we propose to use the time available today. It's suggested, it's a matter for the court obviously, that I go first, followed by my learned friend Miss Williams-Howe for the father, so that we've got both parents making their points, and then in the afternoon perhaps we hear from the local authority and from the official solicitor. That divides people in terms of supporting the appeal and not.
We're all content for you to divide it up as you feel to be appropriate.
I'm very grateful. Thank you. My lady, Lords, permission for the appeal was given by Lord Justice Peter Jackson on the basis that he did not think that the appellants had any real chance of success, as he put it. So I'm starting submissions from the always interesting position of having nothing to lose and perhaps everything to gain. The proposition put forward by the appellant is simply summarised. It is that the learned judge erred in granting the local authority application for a declaration of non-recognition because the remedy was not, although it was generally, it was possibly available in extreme circumstances, it wasn't available in this case. And the court should have told the local authority to proceed by way of an application for nullity or divorce. Nullity was an option at that stage.
Can you just help as to how the local authority, sorry to jump in so early, in the course of your submissions, how the local authority could bring proceedings?
The local authority would not be able to bring the nullity proceedings. The nullity proceedings would need to be brought on behalf of the protected party by a litigation friend, because there is a lack of litigation capacity, with the permission of the Court of Protection, indicating that that is in her best interest. So we would have to go through the stages.
Sorry, because I thought your submission was the local authority should have brought nullity proceedings. That's what I heard. I obviously misheard you.
No.
So
What I said, I think, was the court should have told the local authority to proceed by way of. So they couldn't do it themselves because they wouldn't be a party to the nullity proceedings.
Yes.
The process would have to be the Court of Protection says it's in her best interest to do this. Then a litigation friend is appointed, not necessarily the official solicitor, maybe otherwise. And then an application would have to be made on her behalf. And then we would have to see whether the putative husband was going to respond, and he would be able to be a party to those proceedings, even though he is in Bangladesh. So I hope that addresses my Lord's point. It may be helpful to the court to just clear the decks of what's not argued by the appellant. The Mental Capacity Act 2005 gives the Court of Protection power to make best interest decisions on capacity and best interest, and those decisions cannot be appealed. They were within the ambit of the judge's decision, having heard the oral evidence. Secondly, contrary to the claim which is in the OS refined skeleton, paragraph 11, it's not suggested that this was not a forced marriage. There was a lack of consent, and therefore it fits within the definition.
I'm glad for that clarification, because certainly your submissions, well, they'd get perilously close to saying it doesn't really count as a forced marriage.
The forced marriage protection orders are in existence and they're not appealed. So we can't really argue that this was not a forced marriage. There was a lack of consent. There was a situation where the judge took the view that the daughter was easily persuadable, and therefore in those circumstances the FMPOs, they're in place and they're not appealed. The third point is the principle of dual domicile on capacity is undisputed. Capacity to marry is determined by English law where the person is domiciled here. The court has decided the person in this matter lacked the mental capacity to marry, and this was not appealed. Fourthly, the Court of Appeal can't overturn the Westminster case as such, but it can better define its meaning and import. Fifthly, it's undisputed by the appellant that the High Court retains the safety net of the inherent jurisdiction which derived from the parens patriae. However, it'll be argued that the availability of the inherent jurisdiction is subject to statute, that the inherent jurisdiction lies beneath and the statute has come on top, and that will therefore be the first basis upon which any decision would be made. The statute, in effect, overlays the inherent jurisdiction. So the courts can make inherent jurisdiction declarations of non-recognition in exceptional cases which are not covered by the statute or where there is a gap in the statutory cover. The sixth point is that the declaration of non-recognition in this case was made on the ground of public policy. But public policy, we would say, is not dependent on the matter before the court. It needs to be ascertained like everything else on the evidence. And in this case, public policy, we say, is known, and it did not, on these facts, allow a declaration. My submissions, more generally, will follow the logic set out by Mr. Justice Mustin in NB and MI 2021 to FLR 786, which is in the bundle at 46 to 99, and also, to a lesser extent, follow the logic, but certainly support the conclusions of Mr. Justice Holman in a local authority v. X and A 2013 DWHC 3272, which is in the bundle at 24 to 33. The argument is essentially that the Family Law Act 1986, sections 55 and 58, contain, restrict, or control, depends on the word that the court would prefer to use, the use of the inherent jurisdiction. And therefore the use of declarations of non-recognition on grounds of public policy. Section 12 of the Matrimonial Causes Act 1973 indicates that a marriage which lacks consent or is under duress, therefore a forced marriage, is a voidable marriage. The remedies are nullity or divorce. Even where these may not be procedurally convenient, quick or ideal, they are, we say, the law. We say the words of the statute are plain and the purpose of the statute is clear. The mischief the law intended to tackle was the unfettered use of the inherent jurisdiction. And I'll come to why I make that claim in due course. If the law is defective, Parliament should be asked to reconsider the particular issue via the Law Commission. Constitutionally, Parliament remains sovereign. Parliament can make a mistake of policy, or in the wording of the statute. But where the statute contains a code of law, it is the role of the courts to seek to do justice within the parameters of the statute, unless the case falls outside those parameters. The inherent jurisdiction is available where there are gaps in the statute. But declarations of non-recognition must be used in line with public policy. Public policy is based on evidence and is ascertainable. It is not dependent on the views of individual judges, rightly or wrongly. The evidence is that Parliament has determined what constitutes public policy concerning the use of a declaration of non-recognition when applied to a non-UK marriage where a UK national lacks capacity. It is not generally available in those circumstances, is our submission. The declaration of non-recognition remains available, as we say, in exceptional cases, which are outside those identified by the statute. Westminster City Council versus C and others, 2009, Family 11, 2008, is the Court of Appeal case, which is regarded by the judge in this case as the precedent. And that, we say, was an exceptional case. It involved a purported marriage over the telephone of two people who'd never met, who lived in different countries, and one of those persons, the person who was domiciled in the UK, had the skills of a 3-year-old. The Westminster case identified a gap in the statute, an exceptional set of facts, but it did not overrule either the statute or, we say, what Parliament has identified as the public policy in this area.
Although they could have gone for nullity because they weren't time barred.
They weren't time barred, yes. They could have gone for nullity in that case. That is correct. The court took the view that it was exceptional, we say. But I'll come perhaps in more detail to it. But that, in summary, is the ground I will seek to cover during the course of my submissions this morning. The route I propose is to firstly say something short and broad about public policy and how it's ascertained, then look at the statutory interpretation issues. Is there a code? What was intended? Thirdly, to deal with some of the list of 5 issues at paragraph 4 of my skeleton. They are in the light of the statements of Holman J and Mostyn J concerning section 55 and section 58 of the Family Law Act 1986. What's the proper use of the inherent jurisdiction? Where statute has set a code of law for dealing with voidable marriages. Next, does the inherent jurisdiction apply to all foreign marriages where a UK national lacks capacity, or to exceptional cases only in matters concerning section 55 and section 58? Next, if it does apply in exceptional cases, then what are the parameters of that exceptionality? And then specifically, does a case like SA's fall within those parameters or not? It then is a declaration of non-recognition available when a nullity remains an available remedy. And finally, I propose, if there is time available, to expand on what I've said about the nature of public policy and how it should be ascertained when the court is using the inherent jurisdiction. So just the quick broad points, first of all, on public policy. I'll take a minute or so. It may be helpful just to make some observations. In my submission, there are two kinds of public policy that are important in this case. The first is the aid to statutory interpretation, to the purposive approach to understanding what the words in the statute mean. And the second is when we move, if we do, into the realm of the inherent jurisdiction, what do we mean by public policy? What is it, and where do we find it? These are two, in a sense, distinct legal issues, but they overlap in terms of the reality, because the court will need to ascertain what public policy is from the evidence. And public policy, of course, can be looked at to some extent from looking at earlier judgments, of course. But public policy is not just the individual opinions of judges. Obviously, judges are concerned to do justice for the individual before them. That's a natural reaction of judges. But judges are not there to express a view about public policy. They're there to ascertain what public policy is and apply it. Because there is always a risk in these cases of confusing the word is and ought. What is public policy from what the judge thinks public policy ought to be. So my proposition, which I'll argue a bit later in more detail, is this. Public policy is the public policy set by Parliament and the state. It is to be ascertained from evidence, judicial intervention based on what ought to be public policy leads to inconsistency and bad law. So the first step in ascertaining both the law and the public interest for the purposes of the inherent jurisdiction and the use of it is to identify what Parliament has said, particularly in cases like this where it has a view, is public policy, and also what the Law Commission has said. If it's called public policy, then it is relevant what is decided by Parliament to be public policy. And I will argue that considering the use of the inherent jurisdiction, the court does not need to look far in order to find out what public policy is, because Parliament has told us. I'll hope to illustrate that argument as we go through, and perhaps now if I turn to some of the statutory interpretation issues that set out at paragraphs 17 to 27 of my skeleton, not following exactly in that order. It's probably useful to start off with the Matrimonial Causes Act in 1973. Section 12, 1C says that there are grounds on which a marriage is voidable. Either party to the marriage did not validly consent to it, either in consequence of duress, mistake, unsoundness of mind, or otherwise. And we say that applies to this case. The Law Commission in 1970 justified the view that a lack of consent would render a marriage voidable rather than, as it had been before, void. And the court will be able to see that the Law Commission report starts at, I don't know if my lords have tabbed
Unfortunately, our
It's just
bundles
relevant.
don't have tabs.
No, in that case, I'll give page numbers. The Law Commission report is in the bundle starting at, let me just double check, page 432.
For
Now-
future reference, it is very useful if the authority's bundle is tabbed.
Yes, indeed. Apologies for that not being done. I managed to tab mine yesterday, so I have got numbered tabs.
432.
432, yes, is the
Right.
Law Commission
Could I?
report. That is the one in 1970.
I'm just checking that. Yes, because my authority's bundle moves from bundle 1 to bundle 2 in the middle of a case. I don't know whether that's just whether
Yeah.
432.
Yeah, that's where the report starts.
Thank you.
Can I take the court to page 440 and paragraph 13? On page 440. And can I just check that my lords have all got exactly the same bundle, because I know there have been two bundles. So, yeah. So if we're all on 440,
This is
then we're on the right page.
Yep.
Good. The overwhelming view of those that we consulted on our working paper number 20 and who sent us comments on it was that a lack of consent through duress or mistake would render the marriage voidable and not void, and we agree with this view. So the Law Commission had considered this matter with some care, and as we see from paragraph 14, it deals with those who are unable to give consent by reason of insanity. Capacity and mental health are different things, but of course different words were perhaps used then. If there's any doubt that this also includes mental capacity, then that's covered, in fact, at paragraph 59 on page 460. But I'm not taking, my lords, it just confirms that we're also dealing with people who lack consent. The reasons why this decision was made are set out in paragraph 14A to E, going over on to page 441. Perhaps the more interesting paragraph is the one I quoted in my skeleton, which is paragraph D. These are marriages, there are marriages of insane persons which would benefit such persons. If,
Sorry,
for
which
instance,
paragraph? Which paragraph are you on?
I'm on paragraph D on page 441.
Thank you. Yes.
Yeah. A woman marries a man of unsound mind and is willing to look after him, and her care and presence are beneficial to the man. We can find no good reason why the marriage should be null and void, or why third parties should not be allowed to should be allowed to interfere with it by having it declared to be a nullity. So there was a view behind this. Forgive my lady the sexism inherent in the quote, but we're dealing with 1970s.
Kind of used to it.
Indeed, my lady. But it did occur to me when I read it that perhaps that would not be written in that style now. In any event, that was the view in 1970. Marriage would be ended by nullity or divorce. It was a clear policy choice, a public policy choice, by the Law Commission, supported by Parliament and put into law. That act remains law. Perhaps controversial as a view, then and now. But in my submission, a public policy choice was made by the Law Commission, and Parliament accepted that, and it cannot be ignored, that when considering public policy, that is public policy for the purposes of also looking at the inherent jurisdiction. The report at paragraph 15 on page 441 shows the conclusion. The purpose of section 12 of the 1973 Act is explained, and the public policy behind it is explained. Parliament accepted this explanation of public policy and enshrined it in the Act. When it comes to deciding within the inherent jurisdiction, public policy is in Acts of Parliament and Law Commission reports. Of course, public policy is broader than an Act of Parliament, but it is something that we can look at the evidence as to what the policy is in relation to this area.
Well, does this refer anywhere to forced marriages?
It refers to duress, but not to forced marriages as such.
And you pointed to the phraseology.
Yes,
And times have moved on.
indeed.
So this
Public
is 1970, isn't
This
it?
is 1970. Yes.
Public interest and public policy changes.
Public policy does change, but the court has to look at what public policy is and also ask the question, has this public policy in fact changed? Because we can know whether Parliament has decided that it has changed by looking at the amendments to the various sections of this Act. Because there have been, if we look at the bundle, at the sections, a lot of amendments. There are notes underneath setting out when Parliament reconsidered this matter. Did it change those parts of the statute which relate to this? And if it looked at it and decided not to change it, and did so relatively recently, then we know that public policy in relation to that Act of Parliament has not substantially changed. The wording of how a Law Commission report might be phrased may change, but the question is whether public policy has changed. My point only in relation to this is that this legislation was passed with a substantial degree of thought. It wasn't the first view of the Law Commission that they would do things in this way. They moved from void to voidable based upon the submissions that were made to them. And therefore, Parliament accepted that. And as we can see on pages 3 and 4 of the authorities bundle in the footnotes, the 1973 Act, for example, was amended by Parliament in relation to section 12 in 2013 and 2014, so relatively recently. But the wording was not amended. It is, at least the relevant wording here, it is reasonable to conclude that where there is duress or a lack of consent, then the appropriate proceeding by way of remedy is for a petition for nullity, or in the absence of the availability of that, for divorce. So there was ample opportunity in my submission for Parliament to insert the remedy of a declaration of non-recognition in the case of foreign marriages that lack consent or are forced. It did not happen. Parliament did not do that. It didn't forbid it, but we'll look at section 58 shortly. The issue is not whether forced marriages or marriages where a party lacks capacity are
So
wrong.
when did you say those amendments were in 2012 and
2013 and 14.
13, 14? Where's the note? That
The note is at, if we look at pages 3 and 4, I think, of the bundle, the authorities bundle, sorry, my lord.
Oh, okay. So you mean it's set out in the footnotes to the...
Yes, it's set out in the footnotes.
Right, and you're talking about amendments to section 12.
Section 12, yeah,
Right.
we can see the amendments there.
Yes.
And we can see that there were other sections amended.
And
So
so-
Parliament has regularly gone back
Yes.
to considering these issues of public
Okay.
law, family law, and has taken the view that certain amendments are made and others are not.
C's not being considered though.
No.
And they were to deal with, as one can see, the Gender Recognition Act, were they? So what acts were they dealing with, the amendments?
The amendments in relation to Section 12 are the Marriage Same-Sex Couples Act,
Right.
2013.
Yes,
There was a statutory instrument in 2014.
yes.
If we go over the page, there was an amendment. It looks like in 2004.
That would be the
Several.
Gender Recognition Act.
Exactly.
Yeah, the Gender Recognition Act.
Same couple,
and the
same
Same-Sex
sex.
Couples Act in 2013.
Yeah.
So there's no,
There's nothing on.
no. So
C.
the critical paragraph C,
Yeah.
which stems back to the 3-year-old Law Commission, has not been considered since.
Yes. My lady, I don't think we can quite say that, can we? It is the law and the policy is unchanged, is my submission. So Parliament has looked at these matters.
Well,
And decided
how do we
not
know,
to change it.
No, well, then could you tell me when they've considered it? And
Uh,
I mean, we know they've considered these other ones because
Yes.
there's
They've
been
amended.
specific acts that have come in demonstrating which have required an amendment necessarily.
Yes.
All right, so that's why they've had to address it.
Yes.
You're saying you've just made the positive submission that Parliament has considered it and decided not to change, and I'm asking you, how do we know that?
I think-
Because each of these tell us that there's been specific acts which have required changing. So they've had to look at it in that context, but they wouldn't look at other sections necessarily that don't apply.
They wouldn't necessarily look at other sections that don't
So
apply.
what's your
but
basis for submitting that they have considered C and decided not to change it? I'm not saying they haven't. I just
Yes.
need to know
I
your
haven't-
basis for making that submission.
I haven't got a specific reference to say that Parliament has looked at this and decided not to do something about it, or did decide to do something about it. What we have is something else. It is a public policy which it remains unchanged. It could remain unchanged for one of two reasons. One, because there is a specific decision not to change it, or two, because there is no need at this stage and no pressure or
Well, no
requirement
one's
to
just
change
thought
it.
about it.
Yeah, so my claim is more an inference rather than something which I can substantiate.
My concern is simply this. I completely understand a submission that says,
Yeah.
there's the Law Commission, they absolutely looked at it carefully, there's the resulting act, and that remains the position. I absolutely get that. It's a slightly different submission to say, and what's more, in the intervening 40 years, they've clearly thought about it again and clearly made a decision not in any way to alter, amend or update it.
No,
And
but
you were making the latter submission, and I was asking for your evidence to support that submission.
yes, the opportunity was there, and it has not been. Nothing has been done in relation to it. Is the best I can provide
Thank
the
you.
lady with.
What is the relevance of the fact that the Court of Appeal decided the Westminster case in, was it 2008? So preceding what you say was an opportunity to review.
What is the relevance that the Court of Appeal decided to do that? The law
Decided the court had power to grant a declaration, even though there was also power to grant a decree of nullity.
Yes, the Westminster case.
What I'm saying from the point of view of statutory development, you say there's an inference that Parliament looked at it. Is there an inference that when Parliament looked at it, that they also took into account Westminster City Council?
I cannot say whether they did or they did not. There's no evidence that I have that the Westminster City Council case was specifically considered by Parliament or indeed by those ministers who bring issues to Parliament.
Which takes us back to my question. We've no evidence or knowledge as to whether Parliament's ever considered it, or any minister's ever considered it ever since.
Well, then the the submission I make is public policy is what public policy
Understood.
is.
I understood.
Until it is changed,
Right.
and it isn't changed, and therefore, by inference, it remains public policy.
So the public policy is firstly that marriages within the scope of Section 12(1)(c) are voidable, not void.
Yes.
Is that first
Yes.
public policy? And the second is that in order to have a marriage declared voidable or void, you have to bring a nullity petition.
Or a divorce, yes.
Now, you've taken us to the Law Commission report, and you've taken us to paragraph 13 and 14, which is explaining why they think it's appropriate, or they thought it was appropriate, that lack of consent capacity should create a voidable, not a void. Where do they deal with nullity petition? Are you taking us to that separately, or?
No, well, I'm going to come to that when we look at the 1986 Act, because that specifically,
Okay.
the Law Commission specifically, it's much more recent, or somewhat more recent,
Okay.
deals with that. So that's where I propose to deal
Thank
with
you.
that particular question and come to the 1986 Act now. So
So wait a minute. We're still under your second topic, statutory interpretation.
we are, and I'm afraid we're going to be here for a little bit.
No.
Have you left public policy? Sorry.
Sorry?
Have you left public policy?
I've made some broad points on public policy. I intend to, if we could get time, return to it.
Because there are quite a number of cases that deal with public policy from the point of view of the exercise of the inherent jurisdiction in respect of vulnerable adults, in respect of adults who lack capacity, and the reason for it.
Yes.
And there are also, I think you had an email yesterday about the public interest in status from the point of view of whether somebody is or isn't married.
Indeed.
That's a public interest which might relate to public policy.
Indeed. There is a long-standing, well-established public policy which is operated by the courts and also by
No, what I'm saying is the
Parliament.
state is interested. It's not just private interests.
Yes.
There's also a public interest involved in whether somebody is or is not married under English law.
Indeed.
And so in this case, the court could make a finding of fact that the marriage, the parties were not married as a matter of English law because P lacked capacity. As you said, capacity is a matter of dual domicile, and you're not challenging the judge's decision that P lacked capacity. So it means it's not a marriage that's valid under English law.
We are not challenging the judgment in relation to mental capacity in the Court of Protection. The question then becomes, and the issue before us is whether a declaration of non-recognition is available to the court.
I understand that, but
Yes.
the marriage is not a marriage which is entitled to recognition under English law as a matter of fact, because it's not a valid marriage. Because in my submission, not according to Section 12 of the Matrimonial Causes Act 1973, it is then a voidable marriage, so it is a marriage until it is the subject of nullity proceedings or divorce. Section 14 of the Matrimonial Causes Act stipulates that if a matter is to be decided, choice of law rules apply. And capacity is determined, as you say, by the law of the person's antenuptial domicile.
Yes.
He was domiciled in England. She lacked capacity to marry, so it's not a valid marriage under English law.
My Lord, I would argue otherwise, which is that if it is the case that a person lacks capacity, then Section 12 applies and the procedures in Section 12 apply, and whether and therefore the only way available under the Matrimonial Causes Act to deal with this issue is by either nullity or divorce. except in exceptional circumstances which the Act may not cover. And when we go to section 58 of the 1986 Act, we'll see that a declaration is there, not permitted. And again, we say there are exceptions, but they are rare. That is the argument put forward by Mr. Justice Mostyn and supported by Mr. Justice Holman.
Yes, it's remedy.
Yes.
That's about remedy.
It is.
What I'm just saying, your submission.
So my lord is looking at the marriage itself from the start.
I'm looking at, as a matter of English law, what is the effect of the marriage under English law?
The marriage is a marriage if it is a marriage in Bangladesh, in this case. In those circumstances, the court then has to take a view about whether that marriage is a marriage which it will sustain or not. And it has taken a view, made a best interest decision that it will not. And then the question is what remedies are available.
Yeah, but
so it's got to be taken logically.
And you said that you weren't challenging the application of the dual domicile rule.
Yes.
So capacity is determined under English law.
Yes.
And under English law, P doesn't have capacity.
Yes. And under English law, under Section 12, a person without capacity is in avoidable marriage.
Right.
Not in a void marriage, and not in a marriage, or I think the phrase is ceremony, non-qualifying ceremony, or a non-marriage.
So your submission is that she is validly married because it hasn't yet been voided. It was voidable, so it's
voidable.
It's intact unless and until set aside by the decree of nullity.
That is what Section 12 says.
So I think that would be a more direct answer to my lord's question.
But my lord is right. So moving to the 1986 Act and looking at declarations and whether they are available and when they are available now. I propose to follow the approach by Mr. Justice Mostyn in MB and MI 2021 at paragraphs 43 to 99.
Page, please.
44 to 61. But perhaps in my own words, and making perhaps an additional point.
Sorry, can I just, it's just, Section 14 of the Matrimonial Cause Act, it's page 10 of bundle 1. Section 14 is headed Marriages governed by foreign law or celebrated abroad under English law. Subject to subsection 3, where apart from this Act, any matter affecting the validity of a marriage would fall to be determined in accordance with the rules of private international law by reference to the law of a country outside England and Wales, nothing in sections 11, 12 or 13 shall preclude the determination as aforesaid or require. So your submission is that capacity is determined by English law.
Yes.
And that pursuant to section 12, as my lord said, that the marriage is valid as a matter of English law, despite P not having capacity.
Yes.
Until the court makes some order that it isn't.
Exactly.
Thank you.
So even though someone may lack capacity, that is covered by the legislation in Section 12.
Thank you.
Let me take the approach taken by Mr. Justice Mostyn in relation to the 1986 Act, which is to look at the purposive approach first, because look at the source of it and why it is there and why views have been taken that have been taken. And in order to do that, I'll be taking my lords, my lady, to the report of the Law Commission in 1984, which is the source of the public policy in relation to the sections that we will be looking at. Miss Justice Mostyn set out the argument that declarations were not available to the court in relation to foreign marriages involving a UK domicile with a lack of mental capacity.
Paragraph?
Sorry?
Paragraph?
It is throughout that section 44, pages 44 to 61.
So he's starting where he starts the declaration under inherent jurisdiction in
Yes.
paragraph 43 onwards.
He takes us all the way through that argument with, in my submission, a great deal of eloquence and care, looking at the various cases and also bringing us back constantly to what is the law? What does it say? What is public policy here? And that is, in my submission, the correct way to approach the issue. Mr. Justice Mostyn accepts that where a case brings the facts outside the anticipation of the court about what sort of situation might arise, then there will be exceptions, and the inherent jurisdiction will then apply. Prior to 1984, the law relating to family members was then considered by the Law Commission, and the section of the Law Commission reports, there are various of them, I understand, in relation to declarations we can see in the bundle, the authorities bundle, at pages 345 to 430. So if the court turns to page 345, you'll see that that is a report, Law Commission report, dated 22nd of February 1984. The report, and really, I think from paragraph 45 onwards, Mr. Justice Mostyn outlines it, and it may be helpful just to go through briefly what he summarises. The inherent jurisdiction declarations that were being made at that stage were made under RSC Order 15, Rule 6. There were also some Section 45 orders being made, but they related to legitimacy, declaration of legitimation, and that, though Section 45 of the the Matrimonial Causes Act 1973 was later replaced in the Family Law Act 1986. So those declarations on legitimation are separate, and they were taken separately, and they are now covered, I think, by Section 56 of the 1986 Act. But the declarations we are looking at are primarily those in relation to the inherent jurisdiction, and those were covered by Order 15, Rule 6 at that time. The Law Commission report explained that the rule did not specify what declarations could be made. Case law indicated that declarations could be made recognising a foreign divorce, foreign nullity, and at paragraph 47, Ms. Justice Mostyn said it had been held that the declaration could not be made that a marriage is valid or invalid ab initio from the start, although he acknowledges there were some rogue declarations, and indeed that's what the Law Commission report. There was then at that stage some confusion about what relief was available and uncertainty about the jurisdictional criteria for making a claim for a declaration. If we look at page 351 of the bundle, and perhaps 351, paragraph 1.6, the court says that sorry, the Law Commission says, paragraph 1.6, part way down that paragraph, our proposals are limited in scope and their only impact on the court's inherent jurisdiction to make binding declarations would be that so far as concerns matrimonial status. And then legitimacy, legitimation and adoption are added. The declarations available would be limited to those which will be provided by statute. So that is what is proposed to be public policy. Declarations available will be limited to those that would be provided by statute. So this tells us two things. It tells us the purpose behind the words in the Act. It's an aid to statutory interpretation, and it tells us what public policy was, and it's an aid to the court when considering the inherent jurisdiction and how and when it should be used. So we know the intention of public policy at the time that the Act was passed. We know the purpose of the Act. The Act, we know, and we've already dealt with it, has not been amended to change that. And we therefore submit that public policy was set out in the legislation. What is the mischief here that the Law Commission wanted to deal with? Can we look at page 360? Paragraph 2.12 identifies the defects in the present law. The first defect there, paragraph 2.12a, is there is uncertainty as to the type of declarations that could be made by reason of Order 15, Rule 16 under the inherent jurisdiction. So that was the mischief that the court sought to remedy. And if there's any doubt about it, we can look at the next paragraph.
You say the court?
Sorry, I did say the court, I meant the Commission.
Yep.
My apologies. If we look at paragraph 2.13, we'll see a further description of the mischief that was sought to be. It's a very short paragraph, and I invite the court to read it. In part due to the uncertainty in the true relationship between statutory discretionary powers to grant relief, we recommend therefore that
Sorry, which paragraph?
Paragraph 213 on page 360.
Thank you. Yes.
We recommend therefore that a new legislative code based on consistent principles should replace the existing hodgepodge of, a great phrase, hodgepodge of statutory and discretionary relief. In effect, the new statute will determine the declaratory relief available for matters of matrimonial status, legitimacy, legitimation and adoption. So that is what was intended. If we go to page 373, and we look at paragraph 3.28, we see there that the procedures are set out, and towards the end of that page, to 373, we say, in our view, no advantage in retaining an overlapping inherent jurisdiction. We recommend it should not be possible to seek declaratory relief under the inherent jurisdiction of the court in those circumstances where we have recommended specific statutory provision for the granting of declarations in family matters. Furthermore, in those cases where we have specifically recommended that no declaratory relief should be available, this recommendation ought not to be evaded by seeking declarations under Order 15, Rule 16. We do not wish, however, to introduce any further restrictions on the availability of declarations under the inherent jurisdiction of the court. So, limited to marriage, adoption, legitimation. So that's where the court was.
Commissioner.
So, sorry, my lord, I thought you were going to intervene. So there is the mischief that the statute was intended to deal with. The Law Commission wanted to establish a new code of law. Declarations available in specific areas involving marriages would be limited to those provided by statute. The mischief to be tackled was the lack of clarity in the inherent jurisdiction and how declarations were used in the inherent jurisdiction. Therefore, the public policy in my submission behind the Act was clear. When a judge sought to identify what public policy Parliament has set out, then we know what that public policy is, because it was set out. As Miss Justice Mostyn puts it at paragraph 48 of his judgment, at page 45, the reference of the authorities bundle, it is absolutely clear that the Law Commission intended the new code to be the alpha to omega, the ne plus ultra of the legal regime. The report makes clear beyond doubt that it was never intended to do that. They should remain outside the court in residual inherent discretionary power to make alternative declarations, which was a subject that was covered in the code. So Miss Justice Mostyn is very clear that as far as the Law Commission is concerned, these declarations are the declarations for the purposes of marriage. The statute was intended, therefore, in my submission, to clarify, perhaps a better word, matter for the court, control the use of the inherent jurisdiction. The situations with regard to when declarations could be made. That was public policy behind the Law Commission report and the Act.
Can I just ask you on the Commission report, where does it deal with voidable marriages rather than ones which were originally void?
It refers to voidable marriages throughout. I can't give a specific reference to, my lord, but it talks about the remedies being available, being those which are available through the process. So the objective was clearly to say that only certain declarations could be made. And we'll come in a moment to look at what declarations can be made, because in matrimonial law there are some that can be made.
Where did they deal with the reason they wanted parties, well, they didn't want parties to be able to, a party to be able to avoid the consequences of a nullity decree, namely the power to make financial orders?
Paragraph 318.
318.
Yes, on I think that's page 369. Right at the bottom of that paragraph, we see no reason why the jurisdictional rules for nullity should be capable of being evaded by recourse to the declaration procedure.
So we're
Right at the bottom of paragraph 318 on page 369.
oh, that's the one.
And this was the using declarations as a device to avoid ancillary relief, as it was then
Yes.
called.
Yes, exactly. So public policy was to prevent the avoidance of the use of ancillary relief powers of the court in nullity proceedings by making declarations. The purpose of the 1986 Act and public policy is therefore clear. If we look at page 374, we see that the court has said very clearly that there is no advantage in having that overlapping jurisdiction. So the restrictions on the use of the inherent jurisdiction and making declarations in the inherent jurisdiction is limited, but they are there. So the inherent jurisdiction remains, but the Act, it is proposed, will go on top of it and control what is used and what declarations are made. This might assist my lord in terms of his question. If we look at page 371 at the bottom,
Yes.
Paragraph 324, we recommended the court should not have the power to grant a declaration that a marriage was initially invalid or that a person is illegitimate. The court will therefore not be able to grant such declarations on dismissing an application for a declaration of initial validity of the marriage. So the view of the Law Commission is quite evident. It's all set out in my submission quite clearly. So the intention is that even if there is a refusal of a declaration of validity of the marriage, the court cannot then move on to say this marriage is invalid, for whatever reason. Of course, invalidity is not quite the same as non-recognition. The courts have decided that a marriage valid in another country can be non-recognised by a declaration in the UK or in England. The question put by Mr. Justice Mostyn and to a lesser extent Mr. Justice Holman is this: can the court say that when the 1986 Act and the Law Commission set out, after consideration, what the public policy should be, and specifically dealt with this issue of inherent jurisdiction and its uses, that actually, for the purposes of public policy within the inherent jurisdiction, this public policy did not apply? That is, in one sense, the question before us. This is clear public policy, which was accepted by Parliament. So further, if the marriage had taken place, of course, in England, there are protections in the nullity and divorce procedures. In my submission, it is difficult to justify those protections for both parties, one of whom is vulnerable, being taken away because the marriage ceremony occurred in another country, Bangladesh. One point worth making is that there is an assumption that UK law is different to the law in Bangladesh. We simply don't know that. I did note that Justice Moylan in SH and MB 2009, in the authorities bundle at page 291, at paragraph 104, said he'd had the benefit of a Pakistani law expert to confirm the similarity of the law in Pakistan with that compared to England, to make a declaration on the basis that the laws were much the same in terms of consent. We don't know the law in Bangladesh. It was never explored by the local authority who made the application for the declaration, or by the court, or by any other party. But there's no obvious basis for people having more rights because we say that the marriage occurred in the UK compared to marriages that occur abroad.
In family law, sorry to interrupt, in family law proceedings, does the presumption that the foreign law is the same as English law, unless proved otherwise, apply?
Yes.
So we assume that Bangladesh law mirrors English law then?
Well, we can't know that. What
that's
we can
the presumption until parties have
Yeah.
instructed experts and said it's different.
Well, what we do know is that in this case, there was a marriage. There was an engagement, nikah, and then marriage. That is what happened. That was accepted by Bangladesh. It It is a formal one. There is a marriage certificate, which we've seen photographs of, but nothing more. It's not in the bundle.
Yep.
So we do know that. So clearly in Bangladesh, it was accepted that that marriage was a proper marriage at that stage. Lady, you look like you were about to say something, but then didn't.
Well, I just don't know on what basis you say it was accepted by them. I mean, they may have had no cause to know. I mean, presuming my lordship's correct, and there's a presumption it's the same in Bangladesh, then it would not be a valid marriage if the person didn't consent. Couldn't enter into the marriage if they didn't consent. Well, we've no evidence about whether there was proof of consent.
We know that
Bangladeshi law.
we
So
do know
you're
that.
saying
Sorry, ma'am.
they approve. You're basically saying Bangladeshi approved it was fine, but we don't know their state of knowledge. They may have been deceived.
Well, we don't know their state of knowledge. We do know this: at the time at which the marriage occurred, there was no mental capacity assessment carried out. So therefore, there would be no reason on the face of it for the Bangladeshi authorities to ask them to grant. And the parents had not been told that mental capacity assessment had been carried out at that stage, on the 25th of October 2019. It was later carried out, and then the court decided, not appealed, that retrospectively there was a lack of mental capacity. So that's the approach that was taken. The lady's looking at me somewhat sceptically, but maybe I'm misreading.
I hear what your case is on that and your
Yes.
submissions.
Yes. Given that the purpose of the legislation was to control the issue of the use of the inherent jurisdiction, my further submission is this, that any court should treat with great caution any attempt to retreat from what was clearly the intention of the law and the stated evidence of public policy. The Law Commission recommendations are on page, in the authorities bundle at page 394 at the bottom of the page, paragraph 3, and on page 387 at paragraph 7. We see that it says the court should not have power to grant a declaration as to the initial validity of a marriage, even in those cases where it cannot entertain a petition for a degree of nullity of a void marriage because the parties do not satisfy the jurisdictional requirements to grant such relief. And we also see at paragraph 7, the declarations referred to in paragraph 2 above should only be available under and in accordance with the statutory regime. Such declarations and a declaration that the initial invalidity of the marriage should not be available under the court's inherent jurisdiction. So that's the references there are 394, bottom of the page, paragraph 3, and 387 for paragraph 7. Lord Justice Mostyn notes that there's no specific reference to a declaration on the inherent jurisdiction being available on grounds of public policy. It's just not mentioned. Presumably, and it's merely my comment, that it's difficult to know why there would be a need to refer to that, because it was clear that the objective of public policy was to say that these declarations would be made on statute in this area. If the court turns to page, in the authorities bundle, page 408, the court will see the draft clause provided by the Law Commission, and we'll note paragraph 5A. This draft clauses, and if we look across the page, at least on my hard copy, it's page 409. We'll see the comments in relation to paragraph 4 and 5. And in particular, this is the explanatory notes, as the court will see, and particularly on paragraph subsection 5, which is the one that we're looking at. Paragraph A of this subsection gives effect to the recommendations in paragraphs 319 and 328 of the report that the court should not be able to grant a declaration that a marriage was initially invalid, whether under the bill or under RSC Order 15, Rule 16. The effect of this subsection is that an applicant who wishes to have it declared that his marriage was initially invalid will have to apply for a degree of nullity.
That's initially invalid, not initially voidable.
Yes.
So is there anything said about initially voidable declarations?
Well, only what is set out that in the report, that nullity should be the approach taken in relation to dealing with voidable marriages.
Well, I haven't actually seen any mention of voidable marriages in the report. I mean, I haven't read the whole report, of course.
Yes.
But it all seems to have been reference to void, and the public policy is to avoid people avoiding ancillary relief proceedings, as rehearsed in the subparagraph you've just taken us to.
Well, I have read this several times, so I'm
sure you have.
I should be
I'm
able
sure
to
you can
see.
nearly recite it by now.
Yes. I can't remember a.
Well, perhaps we could come back to it, but
I will try and
it would
come
be
back.
helpful just to know if it was in the front of the mind, because certainly what you've taken us through so far, the emphasis seems very clearly on initial validity.
Yes. But if we look, I say, at the plain meaning of the Act
Yes?
itself. So turning now, having looked at the purpose.
Sorry, just one. Your submission is, in fact, that the marriage is valid until declared invalid
Yes.
pursuant to a decree.
Yes.
So, which seems to be contrary to your emphasis on initially invalid, because you say that's not this case. That's your submission.
It's not initially invalid,
Yes.
but the declaration which was made in this case is that the marriage is not recognised. So therefore, what is it? It's not recognised in the UK,
Yes.
recognised in Bangladesh.
Well, we
Possibly.
don't know that.
Possibly.
Well, we know that there's no divorce in Bangladesh.
No, but we don't know about recognition provisions.
The fact
No,
that a
we
marriage
don't-
has taken place in Bangladesh doesn't mean it's a valid marriage. It just doesn't, because that's the whole point. Might be in some cases. The fact that there has been a marriage doesn't prove that the marriage is valid.
A marriage which takes place might not fulfil
Yes.
a
For
ceremonial.
some reason or other.
Yes.
Okay.
There may be a.
So, but
But what we know is that a marriage took place.
I understand
That's
that.
undisputed.
But what I'm
There's-
tussling with is what my colleagues have raised, that this is talking about initially invalid, and your submission is that the marriage in this case is not initially invalid.
Correct.
Right. Okay.
It is a valid marriage until a nullity or other
Until
divorce
avoided.
ends it. Yeah.
Until avoided.
Voidable
Avoided.
until avoided.
Yes.
Yeah.
Yes. Indeed. That's the submission. So if we now turn to the actual wording of the Act itself,
Thank you.
and we can look at page 13 of the authorities bundle. And in particular, section 55 there.
One three.
No, that's wrong. Keep going.
Yeah, 1-3.
No, it's
It's
not
page
1.
14, in fact. Don't worry.
My bundle says that.
Don't worry, we've got there.
You've got there. Is it page 14?
It's
Yeah,
we will.
it's fine.
I take you to the point which my lord had already indicated in a sense, which is section 55 1A says that a declaration, well, let's look at the provision. Any person may apply to the court for one or more of the following declarations in relation to a marriage. That is to say, a declaration that the marriage was at its inception a valid marriage. A declaration that the marriage subsisted on a specific date, or a date specified in the application. So it's worth pausing on section 55 1A, because it only allows a declaration of a marriage that was valid at its inception. So what is inception? The inception, my submission, is when it started, the beginning. Was the marriage ceremony valid? Did it comply? Is it recognisable as a marriage ceremony? The statute plainly means, on a plain reading, that the beginning of the marriage, that it was valid. It was compliant with requirements, including the requirement of capacity. It is important to consider this in section 55 because we're going to turn to the meaning of similar words in section 58. It's unclear, it is very clear that the plain meaning of the word in section 55 1A is from the beginning. The parties complied, the ceremony was compliant, there was no issue of consent. There is no doubt about the meaning of section 55 1A. Could we not recognise a marriage as valid because it was conducted in a state which was not recognised by the UK government? We could, because if the UK government does not recognise that state, the court, it's public policy that it should not be recognised. So that is available, and a declaration of non-recognition could potentially be made in those circumstances. They are limited circumstances and outside the normal remit of the Act. But the plain meaning and the purpose of the meaning of the words in the statute in section 55 1A is that these declarations could be made about the validity of the marriage right at the beginning. Now, a quick point on section 55 1C. This, we say, cannot be used to declare a marriage is not recognised at the beginning because the marriage has to be valid in the first place in order for a declaration to be made later that it wasn't valid on, or was.
Isn't that your case in this case? Your case is she couldn't consent, didn't consent, but it is avoidable marriage. So declaration 55 1A, it was a valid marriage. Declaration 55 1C, now that the official solicitor is involved and has recognised the true position, avoided, and therefore it doesn't exist anymore.
No, because Hudson and Lee, Mr. Justice Bodie observed that the making of a declaration pursuant to section 55 1C would be wholly impermissible as being a device to get around section 58.5. So this is not, in my submission, a way around section 58.5. When we come to look at section 58.5, 58.5, we'll be able to see what that says. In fact, perhaps if we move to that now, section 58, look at 4 and 5, so that's just over the page. Over a couple of pages on section 58.
But 58.5 deals with it being void at the start, and your case is, and indeed that seems reflected by section 12 that it was voidable rather than void.
It was voidable. Yeah. Our position is that the marriage was voidable.
Yeah.
Um,
So 58.5 has nothing to do with it because that talks about it being void at the start.
Well, void means that it did not exist. And a declaration of non-recognition is a refusal to recognise the existence of a marriage at the start, that it was not recognisable in English law.
Well, that's confusing voidable and void.
Well, Lord, I hope not, because what we're looking at is whether a declaration could be made, which in effect concluded that though this marriage was voidable, in theory, in practice, it would not be recognised in English law because it was not something that was valid at the start.
But that's different. Recognition is different.
Well, recognition is whether English law will recognise that marriage as being a marriage that it can accept as valid, surely. And no declaration shall, paragraph 58.4 is no declaration which may be applied for under this part may be made otherwise than under this part by any court. So there's a prohibition in there.
Well, that's 4 is just if you can get the declaration under the Act, you have to go under the Act.
Yes.
That's all that says.
Well,
5 is the one you are focusing on.
yeah, 5 is...
You're saying that, your submission is rather, that the a declaration as was made in this case has the effect of a declaration that the marriage was at its inception void. That is how
Yes.
I understand your submission.
It's not recognised, it's not accepted, it's not something that the English law will recognise as a marriage which subsists.
Yes, but it's as my colleagues have said, it's not saying that it's at its inception void. Indeed, your case is that
It's
it
a
isn't.
voidable marriage.
No, your case is that under Bangladeshi law, it's a valid marriage.
It's a valid marriage.
Whether that's your case.
Yeah.
So your case is it's valid under English law, valid under Bangladeshi law, that it remains valid if an application was brought or a petition was brought under the provisions of the Matrimonial Causes Act. It would be voidable from the date of the order, whatever it's now called,
Yes.
decree.
Yes. So it exists up to that point.
So it exists up to that point.
Yes.
So how does that conflict with at its inception void?
At its inception void is if no declaration can be made that a marriage is at its inception void, not a marriage, not an accepted marriage. And therefore, what does a declaration of non-recognition do? It effectively says that this country does not recognise that that marriage was, at its inception, a marriage which, I'm trying to avoid using the word valid, but which was acceptable. So there is a real risk here of making distinctions that don't have a difference. And words do matter, but so does the concept that they are addressing. And a statement of a declaration of non-recognition effectively says this is not something we in the UK or we in England will accept as a valid arrangement of a marriage. And what the Act specifically says is you can't make that declaration if it means you're saying that the marriage was at its inception, at the beginning, something which was not a marriage. It was void. So what we say is that if we look at section 55 and 58 together,
So for the purposes of your submission, we have to put out of our minds that under the MCA this was a voidable marriage, not a void marriage.
no, our
Because
submission
otherwise we're back to where my Lord Justice Dingemans takes us.
no,
That-
it was a voidable marriage, and my lady, you don't have to take that out of your mind at all. What I'm seeking to do is say what was done with this declaration was effectively to say the marriage was void at its inception. And that's what the declaration did. Whereas, in fact, it wasn't. And the court can do that because it was valid at its inception, and the court could make an order, and the Court of Protection certainly could make an order that's in the best interest that this marriage should end now. And that's certainly within the remit of the court, and that's the view of the judge. But then the only question is whether he could make a declaration of non-recognition or not, or whether he had to go down the route of nullity or divorce. And our submission is nullity was available at that stage, and that's what should have been done. That's simple. So we say the plain meaning of no declaration being made by any court, whether under this part or otherwise, that a marriage at its inception is void. If we look at the plain meaning of that, it is about the beginning of the marriage, and it is straightforward. I can go into how Benyon addresses plain meaning. If the court wishes,
Pretty familiar with that, thank you.
yeah, but I'm sure the court is very familiar. And if we look at what the mischief was, if we need to look at it further, the mischief is set out in the Law Commission report, which I've already identified.
Well, it was to stop people circumnavigating ancillary relief. What it says in
Yes,
the recommendations.
indeed. Absolutely. It was. And therefore, to do so by way of...
It wasn't to prevent people that had been subjected to forced marriages.
Yes. Yes.
It wasn't the policy.
So, one of the mischiefs was also the hodgepodge of decisions under the inherent jurisdiction, an attempt to try to get control over that.
Can I just ask you about the declaration that was made in this case, which is page 86 of the bundle? And what it doesn't say is that it was void at the beginning.
No.
It says the marriage
It's not recognised.
between X and Y, which took place by a ceremony on a date in Bangladesh, is not recognised as valid in this jurisdiction, which is entirely consistent with it being voidable at the start and now being not recognised as valid in this jurisdiction because it has been avoided now that everyone has understood about issues of lack of consent.
Well, it could be read like that.
Yeah,
I
and
accept that
consistently with the statute.
it could be read like that, or it could be read that this is the date the marriage happened and it's not recognised. Is there a suggestion that the marriage was recognised as valid throughout? And the judge, I think, broadly accepted that this fell within the voidable category. And that's what the statute said, but then took the view that a declaration was available to him. And the question I'm seeking to look at is indeed whether it was.
Well, I
Lord
thought
asked
you'd
me the
accepted it
perfectly
was.
straight.
Sorry, I thought you accepted it was available to him, but he shouldn't have made it because he didn't fall in with your exceptionality.
That's exactly
Are you now changing that and saying it wasn't available to him at all?
It wasn't available to him in this case.
Right.
Is our position.
That's what I thought.
It is not.
Sorry, I thought you were backtracking from that and saying it wasn't available at all.
No. What I'm saying is hopefully clear that there are situations which are quite exceptional, quite rare, where things happen that clearly haven't been anticipated, and it takes us outside the remit of what was anticipated, and therefore the inherent jurisdiction can then be used and a declaration can be made. And the question is, was this one of those cases? And our submission is...
And just so it's clear, what I was putting to you was that what happened here is entirely consistent with the scheme of the Act, and you don't even need exceptionality. You only need appropriateness.
As far as the declaration is worded, it's not clear what it means. It could be read, as my lord suggests, that from today we're not recognising that marriage that happened on that date. Or it can be read, that marriage happened on that date, but it's never been recognised. And it's not clear.
Are we helped in the judgment?
Page 86 of the court.
Yeah, no, I've got that open. I was just wondering if the judgment helps us at all on that. I don't think it does, my recollection.
No, it's very brief towards the end. And there's not much that we can say about why the court did not use the route of nullity.
Well, because it was following Westminster.
It was following, yes, that is exactly what the judge said.
Which was the binding precedent, so it's
bound
not
by
hard to
precedent,
tell,
yes.
really.
And my submission will be, when I get to this, is that actually it's not a binding precedent at all. It creates a discretionary relief, potentially, in various cases. And the question is, how broad are those cases? So the judge was entirely wrong in my submission. He was not bound by Westminster at all. He potentially could look at the option of Westminster in exceptional cases. But he wasn't bound by it. It was a discretionary relief in itself. It's inherent jurisdiction. So the whole basis upon which this was decided, I am bound by a case, was wrong. Judge erred in that. But I'll come to that. I'm watching the time. So let me see if I can perhaps make some progress and say that look now at the proper use of the inherent jurisdiction. This is dealt with from paragraphs 25 to 44 of my skeleton. And
So
it's
20...
about 25 to 44. And Miss Justice Mostyn also deals with it starting at page 51 of the authorities bundle. I just wanted to quote paragraph 68 on page 51 of that bundle. The court will only take the exceptional and momentous decision of non-recognition when recognition would violate some fundamental principle of justice, some prevalent conception of good morals, or some deep-rooted tradition of the common weal. That's our case. Yes, there are exceptions to declaring a marriage in effect void at its inception if there is something which is so exceptional and momentous that it takes us outside.
I don't want you to advertise your submissions in advance, but that would follow, therefore, that you don't believe a forced marriage would violate some fundamental principle of justice.
No, it doesn't mean that at all. Of course, a forced marriage violates a fundamental principle, but it brings a forced marriage as such would bring the case within Section 12.
I see.
And therefore, of course, marrying someone who lacks consent is a breach of some principle.
I wasn't talking about consent as such, I was talking about forced
marriage. Yes. But forced marriage is duress, brings us within Section 12. So therefore, that's the remedy. That produces the route to the remedy.
I see.
That's the case.
What happens if it isn't available?
If nullity isn't available,
yes, which it isn't.
3 years have gone.
Yes.
Yes, because then we go for a divorce. Divorce is the next remedy.
Which, yes, okay.
So that's what the
Which
statute
depends
says.
on, yes, the recognition of the marriage.
Yes.
So you say the appropriate remedy to address the situation in this case, because of the statutory constraints, would be divorce.
Not quite, my lord, but almost. What I'm saying is that at the time that this decision was made, nullity was available. could have been
I
followed.
know that.
It is no longer available.
Yes.
We've gone past the date,
Yes.
and therefore divorce is available. And of course, the restrictions on extension of time are quite strict.
Yes.
And this isn't a mental health case. So this is a mental capacity case, and it's different. And the extension can only be given in situations where the Mental Health Act 1983 applies. So I accept that it can't be extended. So we end up, unfortunately, with divorce being the remedy now. And that's unfortunate, but it's the result of the decision of the court. So we say that there are exceptional and egregious factors which can bring the circumstances of a case outside what was the usual duress or lack of consent cases in Section 12. But the use of the inherent jurisdiction is not just another option. Constitutionally, Parliament has the trump card by passing an Act. And if the Act says that this is how you do it, and there are restrictions on how you do it, that's the law. The inherent jurisdiction stays as a safety net if you fall outside that. So it remains unaltered.
But your submissions at the moment are focused on, are they on what circumstances would amount to?
Exceptionality.
Okay.
So, and
you're, go on.
yeah, we're saying that the Westminster case was an egregious case. Someone with the skills of a 3-year-old who was married to someone they'd never met through a telephone marriage. That's likely to be unanticipated. And
So there are what degrees of forced marriage that the court will analyse as to whether one is justified
yes,
and one doesn't?
well, what the court will look at is this the sort of case, a marriage under duress, that would have been anticipated? This is not just a marriage under.
Can you remind me, is causing someone to enter into a forced marriage a criminal offence?
It is. Yes.
Yes.
If those.
Does that give an indication of Parliament's view of a forced marriage?
Of course it does. Yes, but Section 12 also tells us how Parliament wants forced marriages to be resolved.
Sorry?
Section 12 of the
Matrimonial
Matrimonial Causes Act tells us that marriages under duress, forced marriage, are marriages which will be remedied by way of nullity or divorce.
And if it's too late for nullity for whatever circumstances for this incapacitated person,
Yeah.
then that would not present an exceptional circumstances for the declaration of a non-recognition. You'd have to put the person through divorce.
Because divorce is still available as a remedy. There is a remedy available. I mean, it's not convenient.
Unreasonable.
Not easy.
What would it be? Unreasonable behaviour? I got married without consent.
My lord, my lady, I haven't thought that far.
Yeah, well,
but,
I think you should.
Yes, the court, if this matter was proceeded by way of divorce, I'm not a divorce lawyer, but unreasonable behaviour might be a
Except
ground.
the unreasonable behaviour has to
They've
be
now
relating to the spouse. So it would have to be, he was unreasonable because he should have known that I lacked consent.
Yes. A 2-year would fall foul of Section 27 of the Mental Capacity Act,
Absolutely.
2005. So 5 years.
Oh, 5 years.
5 years.
I see.
Or alternatively, something to do with unreasonable behaviour would seem to be the ground. Yes. My lady, none of this is ideal. The question...
Just looking at that brief analysis, if you were then, your only option was divorce, that still wouldn't make it exceptional on your case.
On my case, the question is, what should the court, where this is an appeal?
The reason I say, you know, because in Westminster, which you say is the egregious case, but,
yes.
Well, but Westminster was a case where nullity was still available.
Correct.
Right. So I'm saying, and the Court of Appeals said, however, the non-recognition was appropriate in that case, right? So what I'm asking you at the moment is if in the Westminster case on those facts, nullity was still available and they still made the non-recognition declaration. Are you really saying that if someone is driven to their only option is divorce in the circumstances we've just been discussing, that the mere fact that divorce is available means that that's the route that's got to be taken?
That's the route Parliament has decided should be taken and the Law Commission has decided to be taken. The problem here, my lady, is public policy.
Well, that's why I was asking you about the
Yeah.
Westminster case, because it might be thought that putting someone like SA through a divorce would present the sort of egregious circumstances that made the Westminster Court of Appeal say that a declaration should be made notwithstanding that nullity was available.
Not necessarily so. SA wouldn't be doing this herself, in effect. She would be doing it through a litigation friend with the authority of the Court of Protection, who had made a best interest decision that she should do so. And in those circumstances, that might be something which didn't bear upon her as burdensome. She's not dealing with it personally. It's being dealt with by a litigation friend, lawyers on her behalf. On the face of it, the evidence would be the same as the evidence we now have. It's difficult to see why that would put her in a position which we would regard as egregious.
All right.
It is less than ideal, but it is not necessarily harmful to the vulnerable person as such, because she shouldn't be dealing with it.
Well, we get into all sorts of cultural issues then about
Well, yes, my
the
lady.
fact that she's then a divorced woman, for example.
Yes, there are those issues.
Yes,
but we
quite
also
tricky
know
for her, don't you think?
it is difficult for her. These things are always difficult, but a declaration of non-recognition, particularly when someone who lacks capacity is expressing their wishes and feelings within Section 4 of the Mental Capacity Act, which they're entitled to do, and the court has regard to those wishes and feelings, is that the marriage should continue.
All right. Well, I don't want to take you out of your course because I'm conscious of your time.
I'm conscious
So
of the time.
anyway, the fact that it would be divorced doesn't make it exceptional as your case.
Let me move on to say that as far as exceptional features are concerned, there are exceptional features, and we do accept that that is the case. The wording used by Sir Jocelyn Simon in the case of Cheney, which is at AB 343, which Mr. Justice Mostyn quoted in full at paragraph 63 of his judgment, refers to a marriage that's so offensive to the conscience of the English court that it would refuse to recognise and give effect to the proper foreign law. This was used in the Westminster case by Lord Justice Thorpe and also Lord Justice Wall to justify their decision. At paragraph 3 of his judgment, Lord Justice Thorpe specifically mentioned the use of a telephonic marriage. We say that there are exceptions, they are egregious, and they are not general. It's accepted that Dicey, Rule 5, which is at page 493 of the bundle, says English courts will not enforce or recognise a right, power, capacity, disability or legal relationship arising from the law of a foreign country if the enforcement or recognition of such right, capacity, disability or legal relationship would be inconsistent with the fundamental public policy of English law. However, of course, the English courts do recognise Acts of Parliament and the public policy set out in the Act, and as Lord Justice Wall says at paragraph 55 of the Westminster case, which is on page 258, he endorses the proposition of Mr. Justice Mumby, as he was then, in Re-PS 2007 saying that much the same thing.
Sorry, which paragraph are you in?
I'm in paragraph 55 of the Westminster case on page
sorry.
258.
But have we finished with Dicey?
No, I've mentioned Dicey,
Yes.
and then I'm saying that as far as Dicey is concerned, yes, Dicey says that things may not be recognised if they are, and provides the basis for a non-enforcement or recognition of such right, power, capacity, disability or league relationship which would be inconsistent with the fundamental public policy of English law. We're not disputing that. That is the approach. But if we have a statute and public policy which clearly say that remedies are particular remedies, not other remedies, then that is public policy.
No, I understand that, but we've moved beyond that in your submissions, because we're now dealing with what circumstances, in what circumstances will the court exercise what you would describe as its exceptional remaining jurisdiction to make a declaration.
Yeah. And they would have to be in my submission, and I'm not going to go through...
No, but what I'm trying to identify is what features do you say in this case mean it's not exceptional? It was a forced marriage,
Yes.
lack of capacity.
Yes.
So that might suggest that
Well,
would be
forced
appropriate
marriage
case.
and lack of capacity brings us squarely in my submission within Section 12. And then the question is there something which takes us out of Section 12?
right.
Because that's where we are. It's avoidable marriage. And
And what might take you out of Section 12?
something so egregious, some out of predictability, like a forced marriage with someone with the mentality of a 3-year-old and the to a person they'd never met in another country.
So your submission is forced marriage by itself is not enough.
Yes,
There must be some other
yes.
element.
There must be some egregious factor which takes us outside the meaning of Section 12, that this is a marriage of duress.
You would not describe forced marriage as egregious.
My difficulty here, and I don't want to do that, no, is the straight answer, for this reason, that Section 12 tells us that marriages under duress, which are forced marriages...
So that's a different point.
Yeah.
Section 12 it doesn't refer to forced marriages. It refers to duress.
Duress.
It doesn't refer to forced marriages. We've had legislation quite a long time after the Matrimonial Causes Act that sets out Parliament's view of forced marriages.
Yes.
So it might reflect the public policy view of forced marriages.
Yes.
You can get an order prohibiting them. They're a criminal offence. So why do you say forced marriage, it's only degrees of forced marriage, why do you say forced marriage by itself is not, adopt your word, egregious?
Well, if we look at the judgment, and perhaps it may be helpful if I now come to the actual judgment being appealed. The learned judge at paragraph 45 on page 118 of the core bundle referred to the case. 118.
Yes.
I'm just... At paragraph 45, we hear what the view of the judge was.
Yes, but what I'm trying to get from you is your submission as to why a forced marriage is not, to adopt that word, egregious.
Ah, right. Sorry, my lord. I thought you were asking me why this particular
No,
marriage wasn't. No. A forced marriage, the word egregious or the word exceptional takes us outside section 12. So my submission to you is that duress includes forced marriage, and that
Well,
yes,
that would mean all forced marriages.
it
Because
would
they
mean
all require force, as described in the Act. So how does that? How does a forced marriage that's otherwise within Section 12 come out of Section 12? Just say some feature.
by displaying features such as we saw in the Westminster case, which were quite exceptional and probably unpredicted, takes us outside and shows us that this was not just a marriage where there was a lack of consent, but there were particular egregious features to it, particular unpleasant features to it, that was so objectionable to the conscience of the English court that it could not be allowed to continue, and that particular steps needed to be taken. That takes us into the inherent jurisdiction. So it's an exceptional case. And the question is, was this one?
So one question for you would say we need to decide is whether or not a forced marriage by itself is so objectionable to the conscience of the English court
Yes.
that declaration should be available.
In all cases of forced marriage. Or in all cases of lack of consent. Because Westminster can be read in my submission two ways. It can be read narrowly or broadly. Broadly, it can be read as it appears Lord Justice Wall intended, that marriages which were showed a lack of consent would be able to be the subject of a declaration. In my submission, that takes us back exactly where we were before the Law Commission report.
Yes, but your submissions are seeking clarification from this court
Yes.
as to how and when the Westminster jurisdiction should or might be applied.
Yes.
And so that's why I was just trying to. So, I understood it. You're saying a forced marriage is not so objectionable to the conscience of the English court that a declaration should be available in every case.
Correct.
Depends on the degree of force, the
Yes.
nature of the force, the marriage.
Yes, I mean, severe violence might take it outside.
Right.
Not evident at all in this case.
Severe violence. Anything else?
Severe violence, or some factor which showed that there was a high degree of suffering over and beyond what a marriage under duress or with a lack of consent would be anticipated to involve. So
Can I just go back to one other
Yeah.
part of exceptionality that you referred to? I mean, you've referred on a number of occasions to the person in the Westminster case having operating at the level of a child of
skills
age
of a
3.
3-year-old, I think.
I don't, with great respect, find that to be a particularly helpful analogy. Much more important is the IQ and the way the person is performing and where they fit in the various levels of disability. And I've just, whilst Justice Moylan was asking you those questions, gone back to Dr. Lilly's report. And when I look at page 299, this young person is in many respects on the 0.1 percentile. She's not even on the first centile. She is profoundly disabled. The term of art used by the people the psychologists and psychiatrists that carried out these assessments, extremely low range of ability, is quite extraordinarily low. She's below the first centile of people of adults.
That is
with an IQ score of only 51.
Yes. Without seeking to rehearse the arguments in the cross-examination of Dr. Lilly, it is worth perhaps also looking at for the report of the person who did the mental capacity assessment, at page 232 of the bundle, and also page 234. Because 231, not 232. 231. This is the report which was done by so this is the witness statement. No, it's a report which was done by the person who carried out the assessment of mental capacity, and at paragraph 9.9 on page 231.
Yeah, well, she had a further education. It's not done the trick.
No, it's not done the trick, my lady. Quite right. It hasn't done the trick so far. But what on that page and also on page 233, paragraph 9.18, Mr. Tim Farmer, who did the report on mental capacity, takes the view that some further education might well change the situation.
So she's had the further education.
She has had some, yes.
Yes, she's now had it, and it's after this report, as I understand it. That's right, isn't it?
Yes.
Yes. So she's now had very significant further education. But that's not my point. The point I was seeking to make is you're looking at the exceptionality, and you're saying nothing exceptional here. Forced marriage isn't exceptional. Forced marriage may or may not be egregious. Choose your word. But look at Westminster. The child was operating a 3-year-old, and I'm just drawing to your attention my concern about using operates at a 3-year-old, which can mean a million different things depending on a nursery full of 3-year-olds. I'm looking at the cognitive functioning carried out after the full raft of tests, which show that this young person is functioning at an extremely low level of functioning.
Yes, but this person was able to speak to the judge and did, and wanted to speak to the judge further, does express her wishes and feelings quite strongly, has been interviewed several times, and I'm not disputing...
So we have to set aside Dr. Lilly's assessment?
No, we don't, my lady. I'm not suggesting that at all. I'm saying there are other factors in this case than Dr. Lilly's view about where this person sits in terms of the various cognitive abilities of young people. And there are reasons to take the view that this was not a case, and indeed in my submission the learned judge did, that this was not one of the worst cases at all. In fact, my reference for that is at indeed paragraph 45 of his judgment on page 118, where he says, additionally, having regard to the circumstances, even in a case such as this, which is by no means the worst a court has had to consider in public policy.
Anyway,
it's about halfway down page.
No, I'm familiar with the passage.
Yeah.
I
perhaps if I
perhaps mistakenly referred that to the circumstances in which the forced marriage was arranged and carried out.
Perhaps if I look at the judgment, because I'm conscious I need to come to the end of my submissions now. If I look at the judgment, which is on pages 109 to 120 of the court bundle, the bundle itself, and perhaps at paragraph 16 of the judge's that's 112, page 112. As this is an application for relief under the inherent jurisdiction of the High Court, it is well established that it is only appropriate to engage the inherent jurisdiction if no other statutory mechanism is available to deal with the relevant interests in play. This requires proper consideration of whether statute law covers the position that it can be clear whether there is in fact a gap to be filled, and hence whether recourse is necessary. The prior stage of identification of statutory provisions is of particular importance to identify whether having recourse to the inherent jurisdiction would cut across any statutory scheme per Lord Sumption in Re B. So that's what was said, and broadly, there is no concern in my submission. That's entirely correct, an uncontroversial approach. The learned judge then outlined the statute before moving to consider the case law. At paragraph 44 on page 119, he comments, when having looked at the case law, that generally looking at some of the cases, there are times the language seems to me to be verging on a distinction without a difference. And indeed, that it is that is after all what Mr. Justice Barron said in BVI. Up to this point, in my submission, there can be no criticism of the approach taken by the judge. I hesitate to criticise this judge because, frankly, he was a pleasure to appear in front of, enormous courtesy, and it's always difficult when an advocate has to criticise the approach taken by a judge. With regret, I do, because my submission is that he errs, because he says, nonetheless, I'm bound by precedent. And I say that he's not bound because the precedent, at most, gave rise to a discretionary remedy. The learned judge then criticises the approach taken by Miss Justice Mostyn, saying, having read Miss Justice Mostyn J's decision several times, it is one aspect which he does not grapple. I thought the marriage has no legal effect, not that it does not exist. So he makes that distinction. Well, we know that the marriage existed, there's no doubt about that. There was a ceremony. It was valid in Bangladesh so far as we know. We don't know that it definitely wasn't. Marriage certificate exists. The couple believed they were married. It seems the marriage was probably consummated. At the time, there was no mental capacity assessment because that was done retrospectively. Afterwards, the couple wanted to remain married. These were her wishes and feelings. We submit that the marriage did have a legal effect, if only in Bangladesh and in religious terms. It was otherwise a voidable marriage which exists until nullified. It was only the declaration of non-recognition that made it otherwise. So in my submission, the statute did apply in this case. There was a lack of exceptionality. The assumption was that a foreign marriage involving a person who lacked capacity was sufficient to meet the threshold of public policy and to enable a declaration to be made. There is always a risk that we lose the wood for the trees. The attempt to look at the detail of the case law sometimes doesn't do what exactly this judge said was needed, because he did say that the first step was to find out whether there was a gap. And in my submission in this case, there was not a gap. And the judge erred by immediately moving to public policy and not explaining why Section 12 did not apply and why he took the view this was not a voidable marriage. That was something he ought to have done. He talked about it and then didn't do it. He didn't explain why this marriage was not what was covered by Section 12 and that there was a gap.
On the issue of gap, your submission is absent, absent a divorce.
Yes.
The marriage is valid.
Absent a divorce or nullity, the marriage is valid, yes.
So does that mean, looking at it from the state's point of view, the state is required to accept that the marriage is valid and there is no available remedy which would stop For example, a claim to benefits on the basis of marriage, inheritance on the basis of marriage, immigration rights on the basis of marriage.
As far as rights are concerned, this person doesn't live in the UK in any event, so those matters wouldn't arise except when he applied to come to the UK. As far as the way in which the marriage...
Yeah, well, the question is the state obliged to accept the validity of the marriage because, on your submission, the only available remedy is now divorce, previously nullity. Absent that, everybody, the state included, has to accept that the marriage is valid.
The state has to accept that the laws it has passed apply in this case.
So that the state has to recognise the validity of the marriage.
The state has to... I go back to the wording I'm using, which is the state has decided, so it is a sovereign
I'm not
act.
talking about the state decide. I'm just asking you, the DWP,
Yes.
if a claim for benefits is made on the basis I'm married,
Yes,
the state has to accept, yes, you're married.
yes. But the DWP would then take account of the fact there was a proceedings in place.
What proceeding?
Well, if there was
No, your submission is that somebody has to be found who will act as a litigation friend,
Yeah.
who will make an application
Indeed.
funded by we don't know who,
Indeed.
to the court,
Yes.
best interest, but absent all these steps being taken,
Yes.
the state has to accept, has to recognise the marriage.
Yeah, that is public policy. That is the way the Act works.
No, I'm just trying to look at the consequences of your submission. The consequences are that the state has to recognise that a forced marriage has created a valid marriage.
If this marriage had occurred in the United Kingdom,
Not ifs or buts, the state has to accept that the forced marriage has created a valid marriage.
yes,
That's the effect
Yeah.
of your submission.
it is.
Okay.
But if this marriage had occurred in the United Kingdom and had been a forced marriage without consent, the remedies are clear. The state has decided what those remedies are: nullity or divorce. And therefore, that is the approach that the state has decided to take. It's a sovereign decision by Parliament.
Can I just
Who-
ask? Oh, sorry.
Yeah, sorry,
Sorry,
the only
sorry.
point I was going to make is, should a person who was involved in that marriage, whether the party in this country or the party abroad, have less rights because their marriage was entered into abroad? And my submission would be that they should not. I'm sorry, my lord.
No, don't worry. Sorry, I thought you finished. Can I just ask you, if you're right, that we have to follow the statute, what is wrong with making the declaration that it was valid at its existence but voidable, and that it now doesn't continue to exist because, with the assistance of the official solicitor, it has been declared void?
Because public policy is that there are two routes, and that's that they are nullity and they are...
No, the statute gives you the right to make the declaration under 55(1)(c), and you've rightly pointed out we've got to obey statutes.
Well, we do have to obey statute, but section 5(1)(c) it requires the acceptance of the validity of the marriage at the start. Your proposition
55(1)(a), yeah.
is that we would do that, and we would accept that it is a marriage which exists, and that on the day at which the declaration is made, we now say on this day it no longer exists. We don't recognise it.
Yeah.
That's your submission.
Or question.
it
rather
is-
than submission.
Oh, sorry, that's your proposition to me. That's my submission. As far as that approach is taken, just sort of trying to work my way through the logic of this, what we're effectively doing is saying we've got a valid marriage where Parliament has said it should be resolved by a particular means, but we're going to take the view that we would use the statute at section 55(1)(c) in order to say that on this day it no longer exists, when the public policy behind the statute, we know, is that declarations of this kind should not generally
No,
be
the
made.
statute says you can make that
You
declaration.
can make it, yes. you can make, but as far as the public policy is concerned, that was not the intention in my submission of that particular wording of the statute. It's not geared towards that outcome. That's not the way it was intended to be used, to try to make a declaration that on a particular date we could get around, because that's what effectively we would be doing, the provision in section 58(5).
But when would a declaration that we see in 55(1)(c) be made? I have to admit, I've never come across one.
No.
I mean,
Well, you wouldn't have come across them because they're not lawful.
No, I mean, 55(1)(c) is lawful.
Yes.
So I'm saying,
55(1)(c).
give me an example of circumstances in which a declaration under 55(1)(c) would be made, because I've personally never come across one.
No, I'm not a family lawyer, so...
I'm not sure I have, but I think it might be, for example, when it's a means of giving effect to a divorce. So you say the marriage didn't subsist on a certain day because the previous divorce is or the divorce,
Yeah.
A divorce is recognised.
Yeah.
So that might be one
It's to tidy
situation,
things up, really.
Just to, yeah.
Or giving effect to the fact that it was valid but voidable and has now been avoided.
Yeah. Well, I mean, my lord is much more versed in the detail of family law than I am. But as far as the objective of 55(1)(c) is concerned, it is.
I think one could probably find it, sorry to interrupt you, because the Law Commission says in its report it's not effectively intending to change the law.
Yes.
It's really intending just to codify it on the basis of decisions that have been made by the courts.
Yeah.
So one could probably look through the previous decisions and identify the sort of situations that in which the court had made declarations.
Yes. Yes,
So
my lord. I confess I haven't done that.
One could probably do it in that way, because...
Yeah. My lady, just to finish, the learned judge in my submission identified no extraneous factors that were particularly egregious, particularly bad, other than the fact that this was identified as a forced marriage. It was identified as a forced marriage because of the lack of consent, that the young woman concerned was someone who was suggestible, and it was claimed that it was suggested to her that she should marry him. She acquiesced in this, and that she wanted it to continue afterwards. So we submit that the matter did not come outside the statute. There was no gap in the statute identified by the learned judge, nor was it ever explained by the learned judge. Having correctly stated the law at the start, the learned judge did not apply it as intended. At least he did not explain why the statute did not apply. The only distinctive feature was that the marriage occurred abroad and there was somebody who lacked capacity in it. In my submission, it was a voidable marriage within the terms of section 12. We say that this case, therefore, does not fall outside the parameters. And that nullity was available at the time, and it was suggested to the judge that was a possible route for him. And indeed, the judge was very familiar with and had read several times the observations of Mr. Justice Mostyn. So he was well aware of that. Therefore, as far as nullity was concerned, it was not time barred at that time. It was something that judge could have said to the local authority, that's the route you should go down. There are various difficulties which arose as a result of the failure to go down that route in our submission. First of all, as far as the husband, putative husband in that case was concerned, he lacked rights. He was not involved, wasn't party to the proceedings in any way, had no say in them. We don't know what financial circumstances he was in he may well have been able to afford. We know not, simply don't know. Could he have afforded a lawyer? Could he have facilitated law? Could he have participated in nullity proceedings via a link? The internet is available these days. He remains married in Bangladesh, as far as he's concerned, and this affects his fundamental rights. But he was denied the fairness of being able to participate in any proceedings. He didn't become a party to the proceedings. Nobody suggested he should. Didn't seem to be necessary at the time. These were primarily mental capacity proceedings relating to the whether the person had consent.
Said these were new points that weren't made to the judge below. Were they made to the judge below?
Certainly, the issue of nullity was raised.
No, participation of the
I can't
husband.
recollect whether. I'm sorry, my lord.
But it's not in the grounds of appeal.
It was. It certainly wasn't an issue which was made with a great deal of force at the initial hearing. I think we can say that.
So how does it fit with the grounds?
As far as the grounds are concerned, we say that the preferential route was nullity. That should have been considered by the judge as the appropriate route. We did in the submissions have a lot of discussion about the availability of the declaration.
Because
but
the fact that it was declaration doesn't mean that the husband needn't be joined, couldn't be
No, he
joined.
could have
Somebody
been
could
joined.
have applied to.
He wasn't.
Just so, I mean, I'm not sure that addresses the fundamental issues. It's a procedural issue.
It is a procedural
And
issue.
just
that-
in this case, he wasn't, but
He
in other
wasn't.
cases, he could be.
Yes, and in nullity proceedings, he would have needed to be at least offered the opportunity to join. These proceedings, it didn't appear initially necessary, but as it transpired, by the time we got to whether a declaration should be made, in retrospect, he probably ought to have been a party.
Right.
But that wasn't something that those I represent needed to put forward. It was something in my submission that the local authority ought to have raised.
Oh, really?
Yes, because the local authority was asking for a declaration which would affect his rights. And we also don't know what wealth or otherwise this person might have had, and we don't know the rights.
Well, I don't think this
benefits
goes to the heart of your argument.
No, it doesn't.
So I'm very conscious that you're probably, I don't know what arrangement you made with Miss Williams-Howe.
Yeah, Miss Williams-Howe has been very generous. Perhaps if I finish by just summarising that, I think I set out my case at the beginning, but the judgments of Mostinjay are the key
Well, you
ones.
know, you've used it as your template, and we followed
did.
that.
Yes, and we say that as far as the Westminster case is concerned, it would be open to this court to decide that a declaration of non-recognition could be made in exceptional cases, which was so offensive to the conscience of the English court and took us outside the remit of Section 12. And that the proper approach for the judge to have taken was to have insisted that the judge take that the local authority take that route rather than the one it did by accepting that there was a right to grant a declaration. My lady, if I can assist you any further,
Thank you very
I'm
much.
grateful.
Now, Miss Williams-Howe, we're not going to expect you to squeeze your submissions into 5 minutes unless that's all you have to tell us. We've, of course, read your skeleton argument, which largely tracks
My lady, my lords, if I might be of some assistance, I do adopt the very full submissions made by Mr. O'Brien on behalf of the appellant. If I might only add one thing in the 5 minutes.
Of course you must.
It's just dealing with, well, why nullity or why divorce? If that's such an unattractive option because it's going to take so long, it's going to be so difficult to participate in, there might be a reputational issue for SA. I would say it may be difficult, but what it does provide is certainty. And what I would submit as part of public policy is certainty. I note the 2 cases, my lady, that was very kindly sent to us by yourselves yesterday. And I note from those two cases that the Law Commission are looking at, well what makes a marriage? And the certainty of ensuring that with all the new religious marriages coming in, what gives us that certainty to say this is a marriage and this is a valid marriage? Because that seems to be exercising the Court of Appeal at the start of a marriage. We've had certainty from, I would submit, from the Law Commission, and indeed from the 1986 Act. As has been set out, Section 55, 1C may give some, that might be an alternative route that's not been explored, certainly in the courts, about ending a marriage. But I would only add that if that route had been used, it's sort of a little bit like a nullity, because if you made an application under Section 55, 1C, you're saying, well, the marriage comes to an end, it comes to an end, but what date? What date? And to my submission would be that really Parliament looked at certainty. And certainty, they said, was nullity, and if not nullity, divorce. And that may be unattractive arguments for cases such as this where there are forced marriages. But we've got to look at SA in not now, not just now, but in 10 years' time. And is the court really saying that once capacity's been, because we know that capacity fluctuates. It may be the case that in this particular case, capacity will not fluctuate for certain aspects, but it denies SA the chance to change, to gain capacity.
Sorry, I'm not sure. A marriage is you determine the status of a marriage at the date of the marriage. So if you didn't have capacity then, how does acquiring capacity later have any impact on the fact that you didn't have capacity at the date of the marriage?
Well, it leads to what we have with the Declaration of Non-Recognition is we have a valid marriage in the English courts and a valid marriage in Bangladesh, but it's just not recognised. That's what the declaration is. It's not recognised in the courts in England and Wales. So if SA decided, was able to gain capacity, maybe over the next 10 years, maybe a bit later, but decided that she wanted to change her status, maybe she would fall in love with someone else, or maybe she wanted to move to Bangladesh, we do not know, we don't have a crystal ball, she would have to address this declaration of non-recognition. And it does impact upon her life. So providing certainty, however unattractive it is, in that it may take a long time, I would submit it is very important. Because if the marriage was nullified, or even if the marriage was divorced, it provides her with certainty. She starts at ground zero again, and I would only make that submission.
That's very helpful.
You've reminded me of the Law Commission looking at how marriages are conducted, and they've issued a report, haven't they? Does that deal with forced marriage at all, or is it just simply dealing with the ceremony? Do you know?
I'm afraid, my lord, I'm not able to help you there. I do apologise, but it's
don't
something
worry.
I will look up over
It's a good thing to have flagged up, so thank you.
Well, commensurate with you getting some lunch, but that would be helpful if you had time. Thank you. Very well. 2 o'clock, please.
Close your eyes.